All right, good morning. Hope everybody can hear me. Sorry for the late start. I was navigating the rotary down here in Middleborough. Good morning, Yaya. Good morning, Boo Boo. Good morning, Alpine Stars. Sea Star. Joseph. Tracy V. Hi, how are you? It's been a long time since I've seen you. How you doing? Spot Lynn. Thomas Barry. Hello. Hello. Good morning, everybody. Hi, Kelly and Amy. Good morning to you both. Yeah, so today's kind of an odd day. Well, Dylan has an appointment this morning. I actually have an appointment that I'm heading to. We set up the stream to start at the regular time, and I honestly don't know who's going to be down at court today. I'm hoping somebody's going to jump on at least for a little bit while I'm at my appointment at 8. So we'll see how this all unfolds. But we're really into the nitty gritty here. Look at the past few days and these witnesses, Dr. Riddler, Lapasar, and Crash coming off. Time and time again, like he wasn't hit by a car, period. So the jury's got to be hearing that. I hope they're digesting it. So, good morning, LB. How's Vinny doing today? I hope he's doing all right. Ready? He's getting out of school pretty soon, yeah. Hey, Mark, how you doing, bud? Robin G riding through the Glen this morning. Yeah, so I'm on my way to my chiropractor appointment. I'm getting old, my back's starting to become junk. So I'm gonna go get this thing popped again. I was supposed to go Monday, and my chiropractor was sick, so we shall see if he's going to be there. Hold on, so we gotta get over. Route 24 northbound is moving right along at a good clip, but this is a scary stretch of road here. Yeah, do you think we'll be... Oh, he's done on Friday? That's fantastic. Good kid, smart kid. Man, he's a great kid. Yeah, we always say that about the kids in the movement. How much time they watch their parents get involved in this, and I'm sure they question up and down and sideways why we're so involved. But it's important, and it's a great teaching moment for them. I know last year during the trial was a true summer vacation, mid-trial, and then some. And the kids were down there, and they were out there, and they were learning, and they were living history. So it's definitely it's important for them to learn to know that they have to be involved, and they should be involved. They really should be involved. Can someone confirm that this live is as well? I hit live, and I do this from Dylan's channel. It's a joint stream, and I can't look at both while I'm driving at this point. So, Robin G, if you could just confirm, or somebody confirm. I know you're riding through the Glen right now, but please hold. So going into today, I guess it's junctions. Thank you, Robert G. Jury instructions start at 10 o'clock. So there's areas going to be talking about, you know, big speech that Bev's going to give to the jury, I guess. You know, what they look at, what they consider, just reminders and all types of shit. So, I don't know, it's just, you know, buying time before she gets arrested. Yeah, trucker, thank you. Thank you, Robert G. I'm trying to watch some of the chat as I drive. It's not really the greatest thing. Tracy's sister, how are you? I'm not sure what happened with Aiden yesterday. My understanding is that it wasn't finished. They're going back, but I don't know when the next date is. So if anybody knows, you can let us know, let the chat know. I know they're in there, just people just lying their faces off, from what I heard. So, what is it, 11? I thought today was at 10, Robert G. Oh, today at 11, meaning 8. All right, fair enough. Well, hopefully that gets resolved. I mean, it's such a bunch of bullshit. Somebody's knocking on the door here. Is she there? Dean, are you there from the closet? Oh, I see her. Hold on a second. Hold on, I'm trying to drive it.
In an accident. Hi!
What's happening?
Nothing. I'm in the closet. I'm hidden away in the closet to come say hi to everybody.
That's like your new place to be, is in the closet. People expect it in the morning now.
Well, I'm not supposed to be on my phone, and the cameras don't come in the closet. You can't see. But if I was out of this, then they could see me on the cameras. So
Yeah.
yeah,
Oh, right. So
yeah,
the hidden closet.
right.
Yep.
So I hide in the closet, and then when I'm done, I come out of the closet. There's no shame. It's Pride Month. Good morning, everyone. Good morning, Spooky and Jackie and Lisa and Spat and Kimmy. I can't stay on quick, but I just wanted to update everyone. What a powerful and beautiful thing that was yesterday when everyone held their hands high with the "I love you" sign that Karen came up with. And we don't want the buffer zone taken away at all. Push back, which Bev will do. And Karen and them had asked that everyone, quiet down a little bit because they're getting talked to about it.
Oh, is that what the shush was for yesterday? I saw the shush.
Yeah. So they got talked to, and
Oh,
what will happen is if it keeps on, you know, being too loud and aggressive like that, then they're not going to let Karen leave, like the team leave for lunch. They'll have to stay at the courthouse. And Bev they'll talk, there was talk about pushing the buffer zone back and enacting it. So we don't want that. That was so beautiful and powerful yesterday.
yeah, absolutely.
So just keep on doing it, folks. We only got a couple days left before she's set free of these charges. You know?
I can't even imagine. I can't wait.
I
This
know.
better unfold the way. I mean, after the past few days, what the jury has seen with the crash daddies, all those doctors, Laposada and Rensler, and
Yeah.
the actual crash daddy getting up there. I mean, Jesus, they got to be like, all right, this is ridiculous. And then just Hank's demeanor alone, the way that Hank treats people, they must be
Oh yeah.
furious. I was
Did you
pissed
see?
yesterday listening to him.
I know I haven't even watched all of it yet, but there's a retired Boston police detective wrote in the Justice page. He came out, he used his name and everything, and talked about how there's so much reasonable doubt and how Bev is so biased and Hank Brennan. It was a beautiful, post that he did.
Oh, really? I'll have to look for that.
Yeah.
That's great.
Yeah. Yeah, they're writing in the thing about how powerful that was yesterday. And this isn't us, with the free Karen Reed signs. This isn't us. We're just trying to protect what has happened. Like Jason and them all fought to get us back up in there into the buffer zone. And not only, it wasn't just about that, it's about Karen wants it toned down because they're getting talked to about it.
Right. Exactly.
So
Exactly.
please, everyone, tell everyone when you're down there today. I won't be down there till later. I'll be at Morrissey's office, but just tell the person standing next to you, like, just keep on doing that because that's what the team really wants.
Yeah.
You
No.
know?
Absolutely. It is. It's we've done what we've done. So far, and we've gotten this far, and standing out in front of the courthouse and the whole trial. But let's not ruin it and make it difficult for the team. We got to do whatever we can to make
Right.
things easier for the team.
Right. If the team is asking for us to do it, then we should do it. And that's what's being asked of us. It's from them directly, you know?
Absolutely.
Right. I mean, we all think the buffer zone sucks. We
It
all
does.
hate
It's
it.
horrible. It's a
It is
violation of
horrible.
our First Amendment rights. It's the most un-American
Absolutely.
thing in the world to have them do this. The
Absolutely.
fact that
There's no,
they're getting away with it is bullshit.
it is bullshit, but right now here in corrupt Massachusetts, we have to abide for it, especially if the team's asking. So just,
Yep.
we're all in the same boat. We want to do the big FU, but if this is not the time to do it, let's end this trial with her being free and, just do it. Only a couple more days. Who's live
Yep.
streaming down there today?
Scott just popped on actually.
Oh, good. Then I'll go. I got to come out of the closet and actually go to work. So I love you guys big time. And who's ever down there, please, hands up in silence. It was so powerful yesterday. So powerful.
It's awesome. It's awesome. I love it.
Yeah. Yeah.
Keep on
All
going,
right.
people.
All right, Dana. Love you guys. Love everybody.
All
Thank you,
right.
Robin
Bye,
G
Tina.
and Sherry, for everything you guys do. Free Karen Reed.
Bye, Tina. Scott, what's going on, bud?
Hey, good morning. How are you?
Hear me?
I can.
All right. What's happening, bud? How you doing?
I don't know. My audio is bad down here. Oh, we're doing
Yeah,
good.
you're
I don't
a
know if
little
you can hear me or
you're a
not.
little choppy, but you're good. No, I can hear you all right. What's going down? How's it looking
Yeah, we
down
just
there?
had
All right.
3 women here from New York.
Oh, no shit, huh?
Beautiful weather.
Yeah, it's supposed to get to like mid 80s today, I guess, huh? What's the expectation
Today,
of
regular,
going?
they're going to do a lot of housekeeping today. Obviously, that she's not bringing in the jury today, so both sides
Yep.
have to argue closing arguments, verdict forms. It's all housekeeping today, so I don't know if it'll be
Yep.
a full day for Bev or if she'll end the day, at 1. But meanwhile, you have Aiden Carney, Turtle Boy, over at District Court across the street. His bench trial resumes at 11. There's still a lot of witnesses to be called. Retired Judge Cosgrove, the special prosecutor in the Turtle Boy case, is taking forever. Aiden's attorney, Timothy Bradle, when he was pulling out of here yesterday, I went over and talked to him, and he's like, yeah, I still got 4 or 5 witnesses to call for the defense, and the prosecution hasn't even arrested yet in that case. So that could go all the way till 4 o'clock today.
Wow, huh? Who was that called?
Yeah, Cosgrove is slow as molasses.
No, he's terrible.
Lindsay Gattani, the fake victim. Lindsay Gattani was on the stand, the fake victim herself.
Oh my God, really?
And I don't know what other witnesses the prosecution has. Cosgrove, and then Bradel has his witnesses. I think Paul O'Keefe is still a witness for Cosgrove.
Yeah, it's gonna be interesting. But as far as I understood, they were all just lying their faces off up there as they usually would.
Yeah, I mean, they opted for a bench trial for a reason because there's
Right.
literally no case against Turtle Boy for witness intimidation
Right.
or violating the restraining order that Lindsay Gattani had upon him.
Yep. Oh, it's such bullshit. The whole thing is ridiculous.
It was tough. It was tough being boots on the ground yesterday because we're trying to follow the Karen Reed trial, trying to follow the Turtle Boy trial going on simultaneously.
Yep.
I was switching from free Turtle Boy signs to Karen Reed signs, zigzagging across the street.
Oh my God, Scott! Telling you, it's all coming to a boil now. What's going on down there? How many?
Yeah, I mean,
down there?
I expect. I mean, got like 20 people here.
Oh, that's cool.
People are rolling in slowly. They're coming.
Yeah.
We have
Dean
three
was just
newcomers
saying
here that traveled from New York.
Yeah, how's one just get in for today?
Yeah.
Congratulations.
Morning. By chance? No, I'm not. All right, you're all set then. We're just checking stickers. You don't need one. Have a good day. Thank you too.
Indivisible.
It's kind of my appointment.
The last few days, Karen Reed and her team are not driving in the regular route. So we've been just hanging here on Pearl Street next to the court.
Yeah, they've been coming in like the back door or something, right? They coming in behind the court.
No, their SUVs are taking a different route to get to the courthouse. Because when they were coming down the other way to greet us, there's too much traffic going that way. So
right.
we can stay in the buffer zone as long as we don't have any Karen Reed related signage or apparel. So I'll put my free Karen Reed sign away and grab a different sign that's allowed in the buffer zone.
Do you have like new people showing up that still don't understand the rules, or is everybody pretty compliant?
The only thing that really happened yesterday is people are lined up on Pearl Street at the corner of the courthouse to see Karen Reed getting in and out of her SUV and the lawyers. And people were loudly cheering, and Sergeant Hardman was telling everybody they have to, be quiet.
Yeah.
So I was going around yesterday between 2 and 4 o'clock, telling all the newcomers, we all want to cheer her on and cheer on our attorneys, but we have to be quiet. Otherwise, they're going to push us back out of the buffer zone.
Yeah, exactly.
So Jack, when Karen came back from lunch, she called Jack over to him, and Karen said, "Hey, I appreciate all the support. I want everybody out here, but you guys got to quiet it down."
Yep.
So at 4 o'clock, when she came out of court, everybody just did a wall of silence.
Yeah, everybody held up the hand sign, and that was fantastic.
Yeah, it was actually the mainstream media was filming us in our wall of silence. We probably had like 80 people, greeting Karen and her team as they came out of court, and it was quiet, and that's what Karen wanted.
No, I mean, again, the silence speaks volumes. When we had the last trial, when the witnesses would show up, we turn our backs on them and be quiet. And it was so powerful, well, that was more pre-trial, I guess, but just the same. Listen,
I mean, obviously,
my,
the federal
jump into
judge's
my
ruling on
appointment.
the got ya.
I'll be back on shortly. Dylan will be on.
I'll
soon
talk
as
to you
well,
later.
So I'm gonna be off the grid for a few. Hold down the fort, bud.
New York.
Thanks, Scott.
From Bronx, New York, that are here. Are you staying here for a while, or
Just last night. Are you broadcasting?
yeah? You're on Resistance.
Thank you.
Yeah.
I've never seen such.
No, we've been meeting people from all over the place.
Yeah.
People from Utah, Colorado, Florida, Canton. There's Cantonites here.
Yeah, it is a beautiful area.
Oh yeah, this whole area is like historical. Even the houses.
Oh, the houses are beautifully lit and everything's immaculate. I love it. I didn't hate the snow.
I mean, even the courthouse itself is a beautiful historic building, but it's not set up for modern trials.
Right. It's so teeny tiny.
Yeah, so there's issues with it, but it is a beautiful historic
Do you
building.
watch the trial live from outside?
Yeah. So the buffer zone line going that direction is 200 feet from the courthouse. You can see my pickup truck with the sign sticking out of the bed.
Right.
We hang down there.
I've seen your videos and I'm like, okay, they go here and then they walk down there.
Yeah.
I want to take a picture of the back of your sign.
Oh, the signatures on it?
Yeah.
Yeah.
You got to get these juicy on that.
Yeah, the sign's seen a lot of action. It's been through both trials. So. Yeah. Resistance to silence is what this is on right now. Owen Davies from the UK. Are you gonna hang here all day? Okay.
Yeah.
Previous to 2 days ago, we would exit the buffer zone and go to the 400-foot line, and Karen was driving by that way.
Right.
And her SUV would slow down, and she'd roll down their windows.
I watched.
But in the last few days, they've changed the route, the way they come in. So we're no longer walking down there. We stay right here. But I'll have to get rid of my Karen Reed sign.
Yeah, I can see that sign.
And like that sign,
Yeah.
after 8 o'clock, you can't have that sign.
And it's almost 8 o'clock now, so
Just turn it around and put it down over there. That's all.
Yeah. And then we'll see that one-way sign, Pearl Street.
Yeah.
We love, so we're gonna be right there,
Follow you.
but you just can't have anything that's says free Karen Reed.
Which is against.
So like your pink shirts are fine.
Yeah. That's why we didn't put any.
Her frame sign is not fine after 8 o'clock.
it's 8 o'clock now.
So the buffer zone enforcement free Karen Reed sign, I can only do that till 8 o'clock.
Well, it's 8 o'clock now. Yeah, we got
Yeah.
4 minutes.
So I have to walk to my truck, switch signs. I switched to a sign that's allowed in the buffer zone. As long as the sign doesn't particularly,
Name a person.
like my other sign is corrupted Canton Police and MSP
Right, you're not naming.
need a reboot. So it doesn't have Karen Reed's name on it. There are certain signs that are allowed down here. Like even if you covered up the name Karen Reed on that sign, that sign's actually allowed. The fact that it says Karen Reed makes it not allowed. Like her Just en Route T-shirt is allowed in the buffer zones, even though it's a T.A. Morrissey case. It doesn't directly relate to the Karen Reed case. The buffer zone rules are like nuts. I've got to actually take some of my signs, bring them to the state police, and say, "Is this sign allowed?" The buffer zone on paper, Judge Canoni says it's 200 feet from the courthouse, and it is 200 feet that way, but it's 400 feet that way. It's far, yeah. And then the buffer zone includes the registry of deeds, the district court,
So if you
the entire parking lot behind the registry of deeds. There's actually a map online where you can see the border of the buffer zone. It's large, but at least in the last 2 weeks, we can still be here and be close, but we just can't have the signage and the apparel. And we also have to be quiet. So like when Karen and her team pull up, you can't be cheering and yeah, let's go. We got to be quiet. So yesterday at 4 o'clock, we just did a wall of silence. Because Karen's worried that if we get too loud, they'll kick us out of the Yeah, my phone overheated in the sun. So we're over here on in the shade on Pearl Street, where Karen will pull up at some point, but I think there's an hour delay in court today. So instead of the regular 8:45 arrival, it might be 9:45. I got 8:33. But the crowd is building. I had to switch my sign to a buffer zone friendly sign. Change the settings here.
Jack, don't let him strip search. Yeah. No strip search.
I did not.
The hell are you? Having a pride?
Yeah, the phone overheats in the sun.
I've had that.
Trying to get the live going again. I think I'm back on.
It was black.
I know.
What happened?
this phone is super sensitive to the sun. It overheats.
Yeah, what is it? A
It's an
14?
Android. I don't know.
Oh, an Android? Not an iPhone? Sure is.
Man.
No, mine's got. It's a fuel truck. What do you
Yeah, I'll take the case off, and then I'll drop it, and it'll
I
broke.
know.
Get a hold of that.
I was talking to him about it because I had my neighbors. He was in that big time. And I asked him.
I mean, if court doesn't start until 10, she's not going to be pulling up till like 9:45. Good morning. Going live, but I don't think Karen's coming till like 9:45. I think they're starting at 10 instead of 9.
We give you time to go to the hospital.
Right?
You want a coffee, sir?
No, I got plenty of stuff. I'm good. People brought donuts and coffee yesterday. I was trying to give it away.
I know I saw.
Like half a box of Joe left over, donuts left over.
I don't get a coffee. I'm gonna get a water. But that pastry shop. I went there for the first time yesterday and brought pastry home. It's good. I brought my kid home some of those M&M cookies.
One good thing about lining up to see Karen next to this building is we got some shade. Keep my phone from overheating. Right? Yeah.
We'll have good travel Google though. I'm sure that all these big bags.
Yeah, I think today is going to be all housekeeping, arguing, both sides arguing jury instructions, those stupid Massachusetts verdict forms. Whatever motions remain, instructing the jury about the shenanigans of Hank Brennan, showing the cut up sweatshirt that was cut up by the crime lab, where Hanky Panky Brennan's trying to make the jury think the sweatshirt was cut up on the pavement. And the other thing going on today is Turtle Boy's case resumes at 11 over here at District. But if Karen and her team aren't arriving till 9:45, it's going to be tough to stay live that long, not have my phone battery die. Grab a camera stick now. Already switched signs. We have to get rid of the free Karen Reed sign after 8 a.m. I want to grab a camera stick here. We had a lot of people down here yesterday. The crowd's building. I don't know how big of a crowd we're going to have later. every day there's new people arriving that have traveled here. There's 3 women here from Bronx, New York. That's better. State Police 13 on the bikes. State Police CAT team, Community Action Team, they're in uniform. They're always in front of the court, including Sergeant Hardman. It's a few more State Police 13 bikes than normal. They must be anticipating larger crowds building every day down here. And this goes on all day, every day. Fire trucks and ambulances going down High Street. You watch the trial live, you hear them all the time. And then during the trial hours, a lot of people hang over here at the registry of deeds. As long as you don't have any signs or apparel that address the trial directly, you're allowed to hang down here now. That's a new thing in the last couple of weeks. But as you can see, everybody's lined up here on Pearl Street. There's Karen and her team's SUVs pull up here. So this is the closest people can get to greet Karen and her team. Trying to keep this phone in the shade because it overheats in the sun. A lot of response to wherever they're going.
Yeah. 2 wavelengths.
Yeah. We're live again on Resistance. Do you want to say hi?
Got me today. Enjoying the nice weather.
Yep.
Nothing but love out here, you know?
Yeah. Yep. Karen has a lot of support.
Not just Karen.
No, it's the Sandra Birchmore case. Yeah. All right. Thank you.
He did just come by and yell.
Oh, I did already.
Dennis, what did he say?
He said,
I was just standing on these steps, which is the entrance to this building, and they were like, "Guy, you can't stand on the steps."
That's what the cops finally did.
Yeah.
They put her.
I'm sure all the local businesses downtown, historic Dedham, can't wait for this trial to be over. But today, there was a planned standout at Michael Morrissey's office over in Canton. but sort of bad timing because you got a lot going on over here. You got the Karen Reed case in Superior Court. Get the Turtle Boy case going on in District Court. So it's a bunch of stuff happening at once.
I was in there yesterday. I think you stayed till 1. If you're not over there, they gotta start lining up at 10:30. That's an indicator.
Yeah, they're talking about if you want to get into the Turtle Boy trial, starts at 11, so you got to line up to get in the courthouse at 10:30. There was a big crowd that got in yesterday, and then there was people still waiting outside, waiting for seats to open up. I know. Yeah, and if court doesn't start till 10, then you're not getting in like 9:45, right?
So the attorneys come and park here, and then they always have a car there. They just drop up here and get them somewhere else. Yeah.
No, Karen and her 1 or 2 SUVs will pull up right here. But Hank Brennan's been parking his personal vehicle right there. So you might see him. A Jeep, like Grand Cherokee. But like I was trying to tell everybody, we've been getting bigger and bigger crowds and newer people here, and they're trying to cheer on. And Sergeant Harmon that runs the state police that do security, they get quiet.
Yeah, I guess the stuff that gets.
And then when Karen came back from lunch, she's like telling us directly, "Hey, you guys, if you wanna stay here and hang out, you gotta be quiet." Yeah. No, because the danger is the state police will kick us out of the buffer zone. This is new, and only in the last 2 weeks have we been allowed to be right here.
Yeah, last year we weren't even allowed to be
It's 200 feet this way. If you look down there, you can see my truck with the signs. I'm right at the edge. But the buffer zone used to be 200 feet that way.
Yeah.
So halfway down the church green, in front of the church, that's where we all hung out for trial 1. Bev took that away. She moved the buffer zone line 400 feet. So we can't hang down there anymore.
Are there any, I know, somebody just told me that the blue is their color, and I didn't know that. But,
Oh, you're not okay? I haven't seen any of those. I haven't seen any of the blue shirts. One of them showed up yesterday for the first time.
I don't know anything about the color.
I knew the pink. I hate the way that's like extra so walk on.
Well, in trial 1, they had a couple days where they organized and showed up, but I haven't seen them yet. It's so faint-hearted, fake other side people that show up.
It's not many of them.
There's not many at all. You know, you had the food stamp 5 roll in, and then you had like Kevin Lenahan from Yellow Cottage Tales. He showed up one day with like 20 people.
Yeah, there was like a group with a.
But they were outnumbered like 10-1 by Free Karen Reed people.
Yeah, that
Yeah, that is. Well, see if Sergeant Harmon comes over here and sees that FKR, that's actually a violation.
Really?
For zone, yeah.
It is?
Yeah. Because it says FKR.
Yeah, I guess I'm saying
Well, Sergeant Harmon knows what free FKR means. It's semantics. It's crazy.
Anything to put up there, you know.
Oh, you want it?
Like my sign here is generic enough because it doesn't name any particular parties in the case. Like if this said DA Morrissey is a career criminal, which he is, I wouldn't be allowed to have that sign because it says Morrissey. So this is generic enough where it just says corrupted Canton PD and Mass State Police need a reboot. It doesn't name anybody in this case. It doesn't name Morrissey. It doesn't name, you know.
That says time to go with his name.
Yeah. Yeah, that sign's iffy. Like if he shows outside. But I mean, these state police CAT team, which is community action team, they've been guarding us for both trials. We know all those guys, including Sergeant Hardman, who's the commander, and they're ready for this to be done too. They're tired of it. The buffer zone rules have changed a few times in the last month and a half because of lawsuits filed by Attorney Randazza. The last buffer zone modification was due to a federal judge's ruling. So they've had to reinterpret the rules down here several times.
Scott, your thing's turned back on.
Yeah. Well, when I was standing in the sun over there, my phone overheated. So if I'm in the shade, I'm okay. But now I'm worried about battery life because we don't think Karen Reed's entourage is arriving till 9:45.
It starts at 10?
Yeah, yeah.
Turtle Boy?
Turtle Boy starts at 11.
He starts at 11.
You'll be able to get into the district court. You can line up at 10:30 to get in if you want to see the
Oh,
Turtle
that's
Boy.
going to be over there.
He had a big crowd there yesterday.
Right.
So yesterday was crazy down here
I
Because-
imagine.
because we're all down there trying to listen to the Karen Reed trial. Some people are trying to get in to support, Aiden.
Yeah.
The Glare had Aiden's trial on Zoom on his channel. So some people are trying to listen to two things. They were watching, Hanky Panky Brennan going after Dr. Rentschler all day. Yeah. And then we're also trying to listen to the Karen Reed trial simultaneous.
Yeah, so I didn't
It was crazy.
I didn't hear that they rested yesterday. That the
No, they're not even close.
and that's what it said online this morning. And I was, what?
No, Cosgrove hasn't even rested yet. And then Timothy Bradle brings the defense case. Bradle's bringing at least 4 witnesses. And that Turtle Boy's attorney,
Oh, this guy.
Timothy Bradle. Yeah. So in Cosgrove, the retired judge, that's the special prosecutor, is slow as molasses. It's painful.
It's painful to listen to Brennan too. I'm wondering who's going to play Brennan. What dork can they find to play Brennan in the movie?
So you got Aiden's case still going.
Yep.
You got the Karen Reed trial going on simultaneous. There was portions of yesterday where I went back to my truck and switched signs to my Free Turtle Boy sign. And then I was in front of the district court. Free Turtle Boy. Oh, Karen's coming back from lunch. I switched signs. I come over here. Free Karen Reed. Then I went back over there. Free Turtle Boy. It was like doing double duty.
Y'all going down to 2 o'clock, 2 to 4?
We've been debating that.
Please do. My daughter.
It's just a bad day to do it because there's so much going on down here.
Down there or here?
No, here. Yeah, because you got Turtle Boy.
It seemed like they were out earlier. Was it an all-day affair?
Well,
Oh,
but they don't start bench trials till 11 a.m.
11, yeah.
because the district court, they're taking care of morning business, new arrests, or whatever. So most bench trials in a district court in Massachusetts, they don't start till 11. And yesterday it went 11 to 4, and all these Massachusetts courts do a 1 to 2 p.m. lunch. So you lost that hour.
Yeah, right.
And then Cosgrove is being slow on the prosecution side. the alleged victim, Lindsay Gattani, was on the stand.
Oh, she was yesterday?
And then there's other witnesses that probably Cosgrove is going to call on the prosecution side. And then the prosecution rests, and then it's Turtle Boy's attorney's turn.
Right.
And Timothy Bradle's calling several witnesses.
Good.
So, but hopefully they'll have that case done by 4. And then today is just housekeeping. It's both sides arguing on what the jury instructions are going to be. Final motions cleared up.
So defense.
There's no jury today.
Defense rested today.
Yesterday.
Oh, they did. That's
And then Hank Brennan was presenting the ruse that he was going to call rebuttal witnesses, and he balked.
good
He's not bringing any.
because the asset he was going to bring.
So basically, both sides have rested. So today, what Bev decided to do was keep the jury home, and both sides are coming in today to argue final
stuff. And then rebuttal maybe tomorrow.
Yes, that's what we're thinking now. Possibly closing arguments tomorrow.
Oh boy.
Yeah, I mean, if she wants to limit, the closing arguments to an hour. No, yesterday what happened was Karen's defense team asked for an hour and a half.
Right.
And Bev's like, oh, maybe I'll give you an hour and 15, but I'm not sure. I'm gonna think about it. So that'll be an argument today.
And Brett,
The stupid Massachusetts,
he wants.
the stupid Massachusetts verdict slips will be an argument. And then in any trial, both sides get to argue what the jury instructions are going to be, above and beyond the normal.
Right. Okay.
Like, obviously, Hank Brennan was showing the John O'Keefe sweatshirt that was all cut up in the back. And that was done by the crime lab. So that'll be something that Karen's team's going to be arguing today. Hey, you got to let this jury know.
In the plastic. That's right.
You got to let this jury know to disregard.
Plastic and imagine that.
Well, I mean, Hanky's playing dirty. That's what he's going to do. So if they come in at 10, maybe Bev can call it a half day at 1 if they take care of everything, or they'll have to come back at 2 and finish business.
Oh man!
And then we imagine, and I always get my guesses wrong, that they start the day tomorrow with closing statements, closing arguments. You can have the jury charged by lunch tomorrow. But in trial 1, she didn't want to have them to do closing arguments just before the weekend, because you don't want to do closing arguments and then send the jury home. You want to do closing arguments
when they're powered up and ready to
and then have the jury go right into deliberations.
Maybe tomorrow, Monday.
No, I mean, they could be in deliberations by lunchtime tomorrow. Send them home for the weekend.
Oh, after closing argument, start deliberation. Okay, good.
That's what we're guesstimating.
If
Yeah.
they do it tomorrow, the quicker the better. If they're not waiting and they have their mind set for that, to close the dock open. But that's it.
I forget. That's a good question. Yeah.
That's it.
I think the prosecution goes first too.
Yeah.
Don't hold me to that right now.
That's ideal if they go out with the best.
I mean, we got a good crowd out here, but we have to wait an extra hour. If it was a 9 a.m. court start, she would have got here at like 8:45. Yeah.
Yeah. Yeah.
starting to warm up here, so I think people are enjoying the shade here, and obviously this is the closest you can be when Karen arrives. So it's working out both ways.
Now, listen up.
Last few weeks, it's been people traveling from different states, different areas to be down here. 3 women that came in from Bronx, New York, are here. Rita said she's coming. Yep. She was down here yesterday for a little while, then she left. She'll probably blow off work again. Yeah.
She said she was trying.
Yeah. I was joking with her yesterday. I'm like, you're gonna get fired.
She saw it on camera. She's like, yeah, I told them they don't need me. I'm just gonna leave.
I mean, Rita got busy working on the elections in Canton, trying to get new seats on the select board. And then she changed jobs. She started working full time again. So yeah, it was a very toxic, caustic industrial cleaner. Yeah. Oh yeah. Yeah. Selective crime investigation.
Yeah. It doesn't seem like it.
Yeah, they need at least another seat. They've been trying to pressure Chris Albert into resigning. Otherwise, he's up for election next year. I think it's Lofgren, and I also think Chris Albert too. Because even though they've replaced 2 seats on the select board, they're still outnumbered. It's still the 3-2 vote or whatever. Yeah. Oh, that was different though. That was the Canton Police Audit Board. Yeah. Oh yeah, they put their plants. Yeah. No, they didn't want the police audit at all. So even though the town passed the police audit, they try to kneecap it at every point. And that's why they put McCarthy on it.
Really has something to say in the town. They're not in charge of anything. Oh, yes, they are.
They are though.
I work for a town. We know they are. We know it about it. They were saying.
No, it's a town run like Canton. The select board is the mayor. It is in charge of the police.
It really is.
You know.
Well, it really is. The other town manager.
No, they were looking for any loophole to kneecap that police audit. Select board. Yeah, there's no town mayor. The select board runs the town. They are in charge of the police, fire. I mean, yeah.
Yeah, same. I work for the town to deal with. Oh, okay. Yeah. 2 and 10. They are. They're all included.
You know, like a lot of people don't pay attention to their like little town elections, but it turns out to be very important.
A little combination is dangerous.
Yeah.
What department did you work for?
I went to
Seven years.
Yeah. I said, you know, you have to protect people. You have to get right with the clouds, not for the loud work ethic, but for
Literally gonna have to go charge his phone from have any hope of staying alive. Excuse me.
day. No,
Ladies, I'm live. Do you mind talking on the live? So you're from Bronx, New York?
There.
And how did you get interested in the Karen Reed case? Were you watching Trial One?
Yes.
Do you follow like on YouTube shows like Melanie Little and
The lawyer you know, Vegas guys. And when I just saw like the ridiculousness in the courtroom and like
yeah,
it's
But we
unbelievable.
like true crime. We're interested.
it's a true crime.
Yeah.
It's
See, that's the funny thing is I was never into true crime at all, but I was a Turtle Rider, you know, fan of Turtle Boy. And when Turtle Boy broke the first story in April of 2023, that's when I became involved in this.
I was working when it first started. I was since retired. Now I have more time to watch.
You know,
Yeah.
but it was on the news regular right away. We kept hearing the name. So if you want to get into it, it's
Well, I mean, we all know mainstream media is terrible. So I think a lot of people that have gotten really into this trial were following it on social media, YouTube shows, because if you watch the regular 6 o'clock news, it just falls flat.
Oh no, I learned that decades ago.
Yeah.
You know, I haven't watched the news in probably 20 years.
now we're here.
So most people I see that travel here from long distance to be down here, both in trial one and now in trial two, a lot of them are following in the case. They watch Melanie Little every day, or or they watch Turtle Boy, or they watch some of them. Like they're not into this trial because they watch the news.
Oh, of course not. No, it's
They found out about this trial through social media.
citizen journalists. I like
Yeah.
boots on the ground people. I like to get my information from them.
Because I've met two couples over various days that were from Utah. There's people that have been here from all over. Yeah. Yeah. I mean, even though we have less people physically down here for this trial, mainly because of the changes in the buffer zone, I think this trial is getting a lot more coverage.
Yeah.
A lot more people are paying attention to
And
it.
even just like the outrageous rulings, it's just so egregious. It's so
Yeah.
it's mind blowing. And to think that could happen to you or me,
When you
You know,
think it can't get worse,
worse,
it does.
you're like, oh my god.
Well, nobody's a fan of Beverly Cannoni. I've hated Beverly Cannoni before this trial because she's always been an awful judge, like horrible. Like her last cop on a live trial in this courthouse.
Uh-huh.
She Emmanuel Lopes, a career criminal, shot and killed Michael Chesna, and then when he was on the run, he shot a neighbor. And Bev bent over backwards to make sure he got a fair, quote unquote, trial. She bussed the jury in from another county. She told Michael Chesna's family they can't show emotion in front of the jury. She was very pro-defendant. But in this case, she's anti-defendant because she has to save her genesis, Michael Morrissey.
This should have been moved.
And she should have
This should have
herself.
been moved.
People were arguing that, like, would the defense want to change the venue? Would the judge want to change the venue? And it just wasn't going to happen, I don't think. And I don't think the defense, I don't think the defense minds that much that it's a Norfolk County jury. So nobody ever argued changing venue.
I think they
But
should
you
have.
have to judge.
Well, Deb's not, so in July of 2023, I was down here protesting every court date. And August of 2023, that's when the defense motioned to have Bev recuse herself. That's when the information came out
But it didn't.
about we're going to bury you on the Auntie Bev's cottage. And they had receipts showing that she was renting her Cape Cod vacation home to some of the McAlberts.
Yeah. No, they don't have it.
And her brother Prescott, that's her maiden name, Prescott. So Judge Beverly Cannoni's brother represented Chris Albert in his vehicular homicide case. So the defense brought up all these possible conflicts of interest. Bev took a 15-minute recess and came back and says, "No, I'm good."
No, I can use cards. No, you can't. And we see you, Bev, with your hand signs and your Apple Watch. And
So when Bev came back and said, "I'm not recusing myself," I'm out on the court steps with all the other Free Karen Reed people, and I go, "We're doomed. Bev's not going anywhere. She has to save Michael Morrissey. The fix is in, and we're gonna have Bev, even if it's trial 2, trial 3, it's gonna be Cannoni." Yeah. So I already had zero faith in Cannoni before the trial even started. Yeah. Well, I kind of like the strategy of the defense this time. They're not pushing the third party culprit.
No,
They didn't open the trial. Karen Reed's been framed. Instead, this time around, it's all reasonable doubt. If her car didn't hit, you must have quit. That's it. We don't need to prove who actually killed John O'Keefe. We don't have to prove that she was framed.
And there's so many reasonable doubt. That's just why. There's like so many.
Right. Tim, how are you? Yeah. That's Tim from Canton Community Television. Great journalist. He's been covering the trial. He covers the Free Karen Reed movement too. He'll get B-roll of the crowd out here. He goes to all our standouts wherever we are. Turtle Boy cases, protests at DA Morrissey's office, both Karen Reed trials. Tim covers the Canton local, like select board meetings and stuff. He's been a journalist and warrior.
We can stay correct.
Right now you can hang here, but when it comes time that Karens are going to arrive, the state police will tell you to go across the street.
There.
Oh, over here with us.
Same.
Right now you're sitting right here, but when Karen pulls up, you're not going to be allowed. You're going to have to be over there.
She pulls up from where?
She'll pull up right here.
Here.
It depends which way they come in. They could be coming up the street and then pull in, or they could be coming that way. The traffic's so heavy, they take different routes.
And where are they? In Boston?
Yeah, so Karen's defense team, Alan Jackson and Eliza Little, they just hold up at a hotel while the trial's going on, and Karen stays with them at the hotel, and they war room there.
So there are people here with names on the sign. I put mine on, but there's like, are they gonna be told to put it away?
Like his sign, that's that DA Morrissey cover up.
That,
it's possible that Trooper Hardman could come over there and say, hey, you can't have that sign. Every day it's kind of like you got to try it and see like what you can have. But I gotta go back over here. My phone's gonna overheat.
It's so good.
Hey, what's up? How are you? I'm trying to stay live on Resistance, but I don't know if my battery's gonna last.
Is the connection good?
I have no idea. If you don't mind, it would be nice. It's a USB-C connection.
Oh my God, I'm like,
Rita's here. We were expecting Rita back.
Wait,
All right.
trying to learn how to use this.
Rita, you're live on Resistance. People are asking here if you're coming.
In the morning.
I feel like bigger.
Thank you for your cross-examination of the most incredible witnesses and experts in this country. Thank you for your cross-examination because you proved the defense's case.
Yeah. Sorry, good.
Be quiet when she shows up. No talking.
Yeah. Even though there's no jury. Yeah, even though there's no jury, right?
Yeah, she doesn't want to worry about us getting on it.
Yeah. I mean, I think everybody's on the same page. Because that's how it worked at 4 o'clock. We were all just
Like, love you, yeah.
like 80 people here, and it was just like a wall of silence. But it was actually powerful,
Yeah,
and the mainstream media was filming it.
I bet it was really.
Yeah. But, I mean, it's really hard to guesstimate when the parties are going to arrive here. There's Erica going up.
Yeah, okay. Oh, yeah, that's why they said no, because they forgot, like.
And they just go sit on the other side of the sign. But. So they took the signature.
oh, yeah. Very
I'm
good.
told that that's.
Very good. This really the face on.
Yeah.
Oh.
You know what's too like
Right.
Like, no, just my question, like, I did it already.
I'm not gonna make any lyrics whatsoever.
Okay? That's what she wants. Okay. To do with the church. She has to do that.
Perfect.
What was it? Karen shows up at the entourage today. She has to do it last time today. Remember, just keep it real down quiet. Just give the free Karen Reed sign. If you want no distraction, give her any reason to come down.
She's looking for it.
Great.
Filming this? Yeah.
Oh my God, yeah.
I filmed last time.
Oh, that,
I know, I have to do that. I get distracted.
I have to use the other one.
It's too early.
It was nice yesterday. That works.
Yeah, that will work. Thank you.
All right. Yeah,
Yeah, you did.
yeah, but my 2 signs I had here, they got taken from them. I was too busy doing other things.
Maybe they did.
Mary Ann was there at the very beginning, yeah. Except for he can't read, so whoever wants to hold up. Remember when?
It'll all depend if Sergeant Hartman comes over here. He could say, "Oh, you can't have FKR stuff." But
I don't think.
try to get away with it as long as you can.
She thought she could put it in her bag. She brought her bag.
Yeah.
Because she's making my sign.
But in my hair today, I think as long as we're silent. Not right here.
Well, up until a day or two ago,
They were.
they were being very picky. But by yesterday, even Sergeant Hartman's like, "Yeah, whatever." But my free Karen Reed sign, that's not allowed. But he might allow that. It's hard to tell. It changes on the day. I know, it's very convoluted. Yeah. All right. Trying to keep the phone in the shade. Morning. All right.
This afternoon.
They're trying to do the 2 to 4 standout at Morrissey's.
Yeah. Is that in camp?
Yeah. Well, I think it's 45 Shawmut Ave.
Yeah. Like right in front of the building?
Yeah,
Yeah.
The district attorney's office is in a commercial building. There's several other things in that building. So they usually set up out front, and then they usually organize like a march around the building. I'm debating whether or not to go today, and I go to all of them because there's so much going on here today. You got Turtle Boy's trial still going. That could run till 4. You got Karen Reed going on. So I don't know if they're going to get the best turnout possible because a lot of people are going to want to hang down here, you know? I mean, even Mizzy, who runs the Sandra Birchmore, she was contemplating on whether rescheduling that or not, but I haven't gotten the latest word.
Valley's coming by. No chance. No
Yeah. Leave lunchbox alone. Yeah, ADA Adam Lowry is soon to arrive, and Peter Murphy and Dennis Sweeney are telling the crowd, don't yell at him or jeer at him.
Yeah, that's like a lot of
No.
No idea if this is working.
And they call the bus.
I don't know why my battery indicators are blinking. I don't know what that means. No.
Yeah.
Does that other charger? Does that other charger have a USB-C? Hi. How are you? When I plug this one in, my thing is blinking, like it's not working. So I don't know if this would be any better. You don't have to like turn it on or anything, do you? This thing.
The light should be blinking, yeah.
The battery indicator on my phone started blinking. Like I don't know why. No, with that one. Yeah.
Joanne,
Hi, how are you? Good.
what do you got on? Independent? No,
There's
this
the
thing.
silence. Oh, that's the
All right, well, here.
I know, but see that my phone case, it only fits going this way,
Oh.
and that's that's a different connection. That's the problem. Yeah, see, that's a USB-C.
The blinking, it says, if the power supply is unstable, the charger connection is loose. That's why the battery will blink. So it could be because of the weight.
No, I got it working this time.
Oh, you got, that's what it says, the charger is, certain batteries unstable.
Well, the problem is my auto phone case is interfering with the plug. Yeah.
Don't say it this way.
Yeah, we can't cheer at Lally. We gotta
No,
be nice.
I won't, but I'm just trying to take a picture. So I gotta try to get one in front with everybody for somebody who does. So Donnie's having surgery at the VA in Jamaica Plain, so I'm like, well, I might as well.
There you go.
But are you recording?
It's live.
In my life. Hi. It's just about a 3-mile walk.
Here comes ADA Adam, quote unquote, lunchbox Lally.
Oh, Tara.
Yeah.
So technically, is still on the prosecution team. Although all he does is sharpen Hanky's pencils. He threw him a few witnesses. He did speak a few times. Crowd's grown quite a bit in the last 30 minutes or so. Oh, how are you? It's not working.
Thank you.
Good morning. Oh, yeah. Yeah. Tim, are you in the media pool this week, or are you alternate? You're still getting in though.
Yeah. Yeah.
They grab my oh my god. And I love to. I have 3 pictures.
I don't know.
What's in there?
My girl. It was only down for about. It was only down for about 2 days. It was only down for 2 days.
Oh, yesterday.
I love it today. I thought you were gonna go to.
They got up. He tells stories. Mommy, yeah. Mom took me to 2 different trails, the Charlestown Reservoir.
It's a Metro police on bikes. That's new. Augmenting the state police 13.
Oh, okay.
Oh, yeah.
Kind of in trial one, when the crowds amped up down here, they augmented the state police 13 bike unit with Metrolec.
I'm thinking, yeah, it's adjusting.
This is the most police presence I've seen so far.
Thank you. Just hanging out. Thank you. Appreciate that.
Right.
No, when we're crowding sidewalks, when we yell sidewalk, that means the pedestrian's coming through.
Got you.
Oh, dog.
Or doggies.
You get picked up the last day, so what? Yeah. I'll give you one.
All right, you know what? Sort of funny stuff. Yeah. Come on. Hey, Denise is saying she didn't see me. I wasn't there when you took the picture. I didn't see you. It's Scott's live.
Why, you want to be on the live?
No, no. That's what I'm
I'm trying to desperately keep this phone charged long enough. Because when I'm on a live, I don't have the app, so I can't see what's going on. I can't see the chat. Nothing.
Guys,
Alright.
gotta try and keep the stairs clear.
Right.
Yeah, good luck.
That's important.
I know.
It's courtesy.
I don't know.
So he's already been up once to ask us.
Yeah.
Go the class, go.
All around, no shit.
And,
Don't tell your word.
coming over.
Coming on right now.
Yeah. Right back here. You get in trouble. Like, hello,
You want to? They let you go over there, won't they? They sort of. I mean, they kind of let like.
See what this is costing Lauren to get a tax base today, huh?
Yeah, I know, because now we got Metrolec.
Yeah, boss. Let's take a picture, sure, please. Thank you, boss. Never did that, the Black Lives Matter.
There's no German today. I don't understand. It's the first treatment.
Right.
There was a German scene. I can't believe this. This is crazy to me. It's such a.
Definitely not an hour.
Yeah, she. I take a picture of the dogs. So they left.
Yeah, this is the first day down here that they have Metrolec.
What would be maximum let's see these go red.
Yeah. Oh, right. Yeah.
Plenty of room over there for all the clothes. Can you go there?
I don't see why not.
Yeah, they didn't protect it. This is would be great. That's what she bought me. You look like my Nancy Drew. Call her a Chigo. Chigo. It looks like a Chigo. It's a little smaller.
Now, this is just the first day they have Metrolec. Remember they did this in trial one? Yeah. So to add on to the state police 13 bike cops, Metrolec is like a conglomeration of local city and town police departments to form like a larger like tactical unit for like crowd control or whatever. You see the Metrolec guys, you'll see different towns they're from, like Taunton, Halifax, where all the state troopers are part of the CERT team. But Metrolec is like a conglomeration of a bunch of police departments. Yeah. And they did that last year when we had the huge crowds. And this is the first day I've seen them here. And the crowds down here aren't even close to trial one.
That's what I was just gonna say. It's not even there.
No. I guess they're looking at it just in case a bunch of people start showing up. The jury's not even here today, correct?
Why isn't the jury?
No need for them. Today is like housekeeping.
fat ass.
Today they're going to be arguing jury instructions, final motions, arguing over the stupid verdict slips,
Yeah, the last day before, final.
arguing how long they get to do closings. That's another argument today. No, the defense asked for an hour and a half. And Bev goes, well, maybe an hour and 15 minutes, but I'll think about it.
I don't think she knows how to joke. Oh, Jackson laughed.
Yeah, Bev's a real comedian. Not.
But I have to say, if they took down
Right.
I literally bought a Commonwealth match. Yeah, I mean, like, not going wait them. I Native American. I bought a shirt for every day.
Yeah, I know when Dean is filming down here, or Brandy, or go right over to the cars, but I'm not going to try that today.
Right.
9:45. Should be here soon. Court starts at 10. Is Bev still going to do the 11 a.m. recess?
That's what I was guessing. Yes, she is. She needs her 15 minutes. Make a phone call. Well, update that. Whatever she's talking interview. See that? Sorry. It's something. And then I read something that one juror doesn't seem to know. So that's a little nerve-wracking.
Yeah, I heard that too.
So,
I think that was Jessica Machado reporting that. Like one juror has 5 notebooks full, and there's another juror that's not taking any notes.
so
Or
scary.
I guess that happened in trial 1 too.
And I
Same thing.
like Dylan said yesterday, I think they should sanction, if they don't make a verdict by Friday afternoon, they go into deliberation on Friday. They should be put in a hotel, thanks, Monday, but she won't do that. In a real trial, they would do,
Oh, sequestered, you mean? Yeah.
they should though over the weekend. But that won't happen.
Sequestering jurors just doesn't really happen anymore in modern times.
But in this situation, but I think they online. But honestly, they look online in a better way. Honestly. Everyone's support. I'm like, I get a ticket, it's getting split 3 ways.
Sign. Wondering where my sign went. Fell down. Well, I see it. It's leaning against the back of the fence. Yeah, on days when there is a jury bus, they don't even really want us down there.
Oh, yeah, just, yeah, because they're letting us spread out, that's nice.
Yeah, because there's no jury today, so it doesn't matter. The jury bus pulls up behind the court, and they could see us. It happened in trial one too. I don't know how you stopped, but we never went back there and protested.
Right, no. I was there last year, I found that cemetery back there and wandered around there.
Yeah.
Smoke a joint, wandering around the cemetery.
No, even the most diehard free Karen Reed people, we don't want to screw up the jury.
No, of course not, no way.
So you know what Deb would do? Call a mistrial. Oh yeah, the jury saw a bunch of free Karen Reed people.
And I feel like that's what, I don't know, that's what I get. I bet myself like yelling at the phone. And I don't even know. I text my mom, I'm like, what? That's my mom. I'm like, I'm sitting up on the part of the but like, I see this. Yeah, I see the corrupt. The whole bringing out the shirt with the whole back.
That's something they have to argue today. Instructing the jury about Spanky pulling that stunt.
Oh my gosh, that was insane.
The judge has to tell the jury, don't pay attention to those cuts in the back of the sweatshirt.
That was insane. Prosecution did it. Don't you think that?
She won't do that.
I think Jack is gonna try to get that. Yeah, they come, stay coming down.
Yeah, oh yeah. Not easy to stand on this thing,
It's
yeah.
not at all. I'm not coordinated.
Yeah. Yeah.
All right, folks. Thank you all for being so silent. That's the point.
That was David Yannetti thanking the crowd for remaining silent.
Great job.
Teary-eyed, adopted.
All right.
Yeah.
There you go.
It's Hank Brennan is arriving. Hank Brennan.
Oh, thank you.
Is it Hank moving out of town? Bye.
Are you going out there? Oh, you are. All right, I'm all right. Yeah. It's not right, you know, but
Hank Brennan getting escorted by Sergeant Hardman himself. That- Do you mind grabbing my flag, please? The flag. Can you grab it, please? Leaning against that door frame.
Yeah, if I'm out of here, I'll be.
Jim? Erica waiting to go in for Turtle Boy's case.
So again.
Hi, how are you? Another one? I think you can get into Aiden's at 10:30. That's what somebody said. Sure.
Sure. I'm just learning how to work so. There we go. Thank you. Good thing my sister got this for me. It's came in handy.
Yeah, I know. But then I had to hook a battery pack up.
Yeah, now you got.
So now I'm like holding the battery pack. So I'm not really gaining all the benefits of having the stick. Erica, we're live. Whose chair that you had yesterday out there? It's yours? No, I have it. But somebody said it wasn't your chair, it was somebody else's. Yeah.
I said anybody can use it. You all can sit here.
Yeah, no, I have it. I'll set it up. Yeah. Yep, no problem. I'm not gonna go in. My job is out here. Yeah. She's bending over right now, looking so bad. Yeah, they're letting people in for Aiden at 10:30. I haven't seen her yet. She was here the other day.
1 second. Just 1 second.
Yeah.
Yeah, no, I don't see Altman. You're the dog watcher now. That's Joanne. She's one of the mods on Turtle Boy.
All right.
Yeah. One of my fellow moderators on Turtle Boy.
You got dogs.
To tie him up to the truck.
I'm getting. So yeah. Get out of this. So that's the nod that you know.
All right.
Yeah. Yeah. I hope you have nowhere to go, Ross.
I'm so sorry. Oh, what?
Yeah.
See you with the registry. It's back that way, isn't it? Am I going back?
Yeah. Yeah. No, the registry of deeds is the next building. What? Are you in the parking lot back there?
Yeah. I talked to Amy this morning, and I'm like, I won't make it there by you going in.
Yeah.
Did he already come in?
I haven't seen him yet. I mean, it starts at 11, so.
I thought it was a 10:04. I mean, I thought it was a 10.
No, 11.
Maybe they had to use the bathroom around there.
If you go down the sidewalk by the registry of deeds, there's a side door into the basement. There's a ladies' room in there. They were saying they weren't going to start letting people in until 10:30.
That's shit. So, but there's a lot. There's a lot more people.
Down. Oh, for you can't read people? Yeah, way more. Well, they took away the other end of the buffer zone. There's no space. She extended the buffer zone 400 feet that way. So we used to be hanging out down by the church green, and we had the public parking on both sides. She took that all away. It's just a buffer zone right here. You can be down there as long as you don't have anything that says Karen Reed. It's arbitrary and silly, but
Oh, okay. Good to know. Yeah, they
I'm gonna end this
she was
slide.
just evicted. She was just evicted before they come her.
Oh, okay.
She got. They're on a mission today.
I knew they were gonna.
I don't want to. So I just let her know that she can just walk in behind the side. That's better.
Well, at least you get to exit the buffer zone and not enter the paddy wagon.
Right.
I don't even see that thing down here today. The paddy wagon thing.
I don't know. Something screams, ego today. You know what I mean? All of them.
It's a small. I'm good, thank you.
I know.
No, the crowd's small compared to trial one, and they have just as many cops.
How long do you think you'll be in there?
Oh, the Karen Reed trial? I don't know. She might try to make it a half day, but they're not starting until 11.
Time to get something to eat, right?
Yeah. I'm gonna sign out, people. I'm gonna set up the seating out here and all that jazz. Set up the Bluetooth speaker so we can hear the trial. Maybe check in with the Glairer if he's covering Turtle Boy later. I'm sure this channel will be switching to a court feed soon. So we'll see you later, everybody.
open. You may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor. Laura McLaughlin from Commonwealth.
Good morning, Ms. McLaughlin.
Adam Malik from Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sallyport. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. Laposada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay? All right, so regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today. I think it's,
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
with regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right, you filed, I saw it in email, I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, just as last time, so that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand what the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking an instruction on for the problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions, are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instructions.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense counsel, not from actual evidence in the case, testimony from witnesses who stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated in the case law on evidence. And obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or third-party culprit instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials that packed evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias, the investigator failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it when we were prohibited.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that, not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. but it's strictly for that purpose, okay?
Yeah, understood. That's crystal clear, Judge.
Okay.
And that's really what I was seeking, just clarification based on.
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
Just while we're on page 8, I just wanted to, Alma does have an objection to the DG instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have, did not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to the.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Hill?
And I would also add, Your Honor,
sure.
They did seize her vehicle at around the same time. So, that it goes to, I think, the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, throughout the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from meeting. And it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed throughout the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within saying request for jury instructions or request for humane practice, and then following the DAG and Batista language in the defendant's request for jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and having his testimony from the stand, that initially she said she wanted to be fine with answering questions, but didn't want to get into any details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not evidence before the jury, but as the court is well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that arises to the level of the DAG instruction. So I would ask basically that everything on page 8 prior to the global instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at her residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view The absent witness instruction is withdrawn, so is the,
Not to interrupt.
that's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language covers.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicates now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses. Electronic communication, so I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the part of that accident linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt. Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
So the only,
1 second, let me just pull that up. Okay.
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed.
Speak up.
Merely on third prong malice, as that's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially strange in the situation, and you don't need to see expectation of the jury. To avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. She did not intend to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason. I understand, and I don't necessarily want to.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind. We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the common.
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh.
But I'm going to give it to them now. Can I hand this to the court?
Sure, thank you. All right, so.
The only other issue, Your Honor, is we do have.
Hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence, Ron.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have them redacted, so we
Okay.
redacted. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, but I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, and I hand the
Okay.
proposed copy to the court.
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser includers, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Olau, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy with a copy of the docket, but that may be somewhat helpful with the court's thinking.
Okay, was that on a murder case?
It was not, but it had to do with the felony motor vehicle homicide.
Okay. Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy, please?
Sure.
This is the,
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional instructions. So the Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in his argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence in Dayton, and then certain statements made in reference the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says it's authenticated to her.
Okay.
The exact.
All right. Ms. Giannetti, do you want to weigh in on that?
Yes, briefly, objecting to that, I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. And in fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other statements.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Giannetti? We're going to hear from Mr. Alessi, but
Okay, the Commonwealth does not object to the redactions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
This is a clean copy.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
It should be covered.
Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally?
NNN.
Can it still be that?
Is it redacted, the NNN? Or is it, no, it can say that.
Okay.
But is this the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
Yeah,
So that
our
has to be-
thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect, and then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who
made those cuts as part of her analysis, and that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, you know, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe it's what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
Very briefly, Your Honor.
Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen, mistakes can be made. It was recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper.
it was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi, okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us that closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll have counsel here at 8:30. All right, thank you.
All rise for the court, please.
So, I gotta go. Okay.
Is there already one of these, like, are we swapping?
Yes.
Goodbye.
Here comes the sun, here comes the sun.